The National Assembly urges Supreme Court to dismiss PDP governor's suit over Rivers emergency rule, citing lack of jurisdiction and abuse of court processes. Hello viewers and welcome to InfoGist TV. The National Assembly has urged the Supreme Court to dismiss the suit filed by 11 People's Democratic Party governors challenging the declaration of a state of emergency in Rivers State. The federal legislature, in its response, contended that the plaintiff's suit was procedurally flawed and lacked merit. The National Assembly said this is a preliminary objection dated April. It argued that the court lacks the jurisdiction to entertain the suit and should award 1 billion naira in costs against the plaintiffs for filing what it terms a frivolous and speculative suit. President Bola Ahmed Tinubu had declared a state of emergency in Rivers State on March 18, 2025, suspending Governor Similayo Fubara, Deputy Governor Ngozi Odu, and all elected members of the State House of Assembly for an initial period of 6 months. Following the suspension, Tinubu appointed Rear Admiral Ibokete Ibas, retired, as the sole administrator to oversee the state's affairs during the suspension period. The National Assembly ratified the President's declaration through a voice vote. Recall that the PDP governors, in a suit number CSC-CV 329-2025, approached the Supreme Court to challenge the President's power to suspend a democratically elected state institution and replace it with an unelected one. The plaintiffs in the suit are the governors of Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Delta, Taraba, Zamfara, and Bayelsa states. The Attorney General of the Federation and the National Assembly are listed as the first and second defendants respectively in the suit. All 11 states in the suit asked the Apex Court to determine 6 constitutional questions, including whether the President of Nigeria can lawfully suspend or interfere with the offices of a governor and deputy governor and replace them with an unelected appointee under the guise of a state of emergency proclamation. They further requested the court to determine whether the Attorney General's threat acting on behalf of the President to suspend the offices of the governors and deputy governors by virtue of such proclamations contravenes the provisions of the 1999 Constitution of the Federal Republic of Nigeria and principles of constitutional federalism. The plaintiffs also questioned whether the National Assembly could approve a state of emergency proclamation, including suspension of state executives and legislatures, by a simple voice vote, rather than the constitutionally required two-thirds majority of all members of each chamber. In their reliefs, the plaintiffs sought the declarations that the President cannot lawfully suspend or interfere with the offices of governors and deputy governors or replace them with unelected nominees under a state of emergency. They argued that the President cannot lawfully suspend the State House of Assembly under such circumstances. They further contended that the Attorney General's threat to suspend state officials are unconstitutional and violates the principles of federalism, and that the National Assembly cannot approve such proclamations through voice votes without a two-thirds majority. Additionally, they prayed for a perpetual injunction restraining the defendants from interfering with state offices through state of emergency proclamations. The plaintiffs sought an order nullifying the state of emergency proclamation in Rivers State as published in Official Gazette number 47 of 2025. The governors are asking for an order of perpetual injunction restraining the defendants from suspending or approving the suspension or in any way interfering with the offices of the governor, the deputy governor, and or the House of Assembly of any of the plaintiff states by way of a proclamation of state of emergency or in any manner whatsoever or by any method howsoever. An order setting aside and nullifying the Official Gazette number 47 of the 2025 State of Emergency Proclamation 2025 made by the President of the Federal Republic of Nigeria and wrongfully approved by the second defendant, and upon which the ominous threat by the first defendant against the plaintiffs is predicated. However, the National Assembly, in its preliminary objection, faulted the plaintiff's suit and urged the Supreme Court to dismiss it, arguing that the court lacks the jurisdiction to entertain the case, particularly against the second defendant, which is NAS. Declaring that it holds a memorandum of conditional appearance, the National Assembly argued that due process was not followed in instituting the suit, emphasizing that the plaintiffs failed to issue the statutorily required 3-month pre-action notice to the clerk of the National Assembly as mandated under Section 21 of the Legislative House's Powers and Privileges Act 2017. It stated that a person who has a cause of action against the Legislative House shall serve a 3-month notice to the office of the clerk of the Legislative House disclosing the cause of action and relief sought. Additionally, the National Assemblies argued that the plaintiffs did not secure resolutions from their respective state houses of assembly, a prerequisite for approaching the Supreme Court under its original jurisdiction provisions outlined in the Supreme Court Original Jurisdictions Act 2002. Citing alleged threats referenced in the plaintiff's suit, which borders on a statement attributed to the Attorney General during a press briefing, NAS noted that since the threat did not emanate from them or its officers, the suit has no business with them. The objections reads in part: considering the affidavit in support and the threats alleged, which did not come from the second defendant, there is no cause of action against it. This is a suit relating to an alleged threatened declaration or proclamation of state of emergency in the plaintiff state by the Honorable Attorney General and Minister of Justice. This is allegedly as a result of the statements of the first defendant in a press briefing held March 19, 2025, wherein he is said to have stated that after River State, it can be anybody's turn tomorrow. None of the alleged threat or statement is alluded to the second defendant or any of its officers. The National Assembly further contended that with the objections amongst others submitted, due processes of instituting the actions in the suit was not followed by the plaintiff before taking these steps against the second defendant, as the plaintiffs failed to issue the requisite 3 months pre-action notices to the clerk of the National Assembly and took no steps to obtain the resolution of the House of Assembly of each of the states to enable the plaintiffs each join to approach this busy court pursuant to the provisions of Supreme Court Original Jurisdictions Act 2002 on the matter. NAS asserted that the plaintiffs were attempting to use the Supreme Court to dictate how it exercises its constitutional role, particularly regarding the use of voice votes to ratify states of emergency under Section 305 of the 1999 Constitution. The objection described the suit as speculative and an abuse of court processes. In the suit, the plaintiff seeks to use the court to curtail the manner in which the second defendant votes or make approval to ratify proclamations of state of emergencies declared pursuant to Section 305 of the Constitution of the Federal Republic of Nigeria, 1999, to get two-thirds majority of their votes. It also seeks that the court dictates how much roles are to be performed by the second defendant. The suit seeks to restrain the second defendant from using voice votes to get majority approval for future or anticipated proclamations of state of emergency in the states of the plaintiffs. The suit also seeks perpetual injunction to restrain the second defendant's houses, Senate, House of Assembly, from carrying out their constitutional duties of approval of proclamations of state of emergency, and seeks that the approval given by the second defendant on the 20th day of March 2025 ratifying the proclamation of state of emergency in River State be set aside for being wrongfully approved. NAS further added that the second defendants, having observed the several deficiencies in the suit of the plaintiff, which goes contrary to the provisions of the laws and the jurisdiction of the court, raises objections and submits that the 11 states which are the plaintiffs approached the court wrongfully and in abuse of court processes. It predicated its objection on 6 grounds, stating that the plaintiff's suit lacks a cause of action. The National Assembly further stated that the plaintiffs lack local standing to proceed against the second defendant On issues raised in the suit, it also argued that the plaintiffs failed to comply with due processes as stipulated under Section 2, Schedule 2 of the Supreme Court Additional Regional Jurisdictions Act 2002. The second defendant noted that the court lacks jurisdiction. In an affidavit supporting the notice of preliminary objection deposed by Gosri Onyebu, a legal officer in the Directorate of Legal Services National Assembly, he argued that due process was not followed in instituting the suit. Onyebu maintained that no dispute exists between the plaintiffs and either the government of Nigeria or the second defendant. He further deposed that the plaintiffs did not obtain the required resolutions from the Houses of Assembly in their respective states to authorize the suit under the Supreme Court's original jurisdiction. There is no cause of action against the second defendant as no threat emanates or emanated from the second defendant's offices. That the plaintiffs lack the local standing to institute this suit, as none of the plaintiffs has shown that it has suffered anything far and above any other persons or people of River State. There are also no dispute involving questions of law or fact upon which the existence or extent of a legal right depends between the parties. The plaintiffs has not established any legal right against the second defendant to warrant equitable reliefs such as perpetual injunctions. He noted that the Supreme Court lacks jurisdiction to hear the matter against the second defendant as constituted. In addition to requesting the dismissal of the suit, Onyebu called for a cost of 1 billion naira to be awarded jointly and severally against the plaintiffs in the interest of justice.